email that was sent to you. The certificate of completion will be sent to you within 1 hour after the webinar is finished. If for any reason you do not receive your certificate, please let us know, because we have 30 days where we can get you that certificate. So right now would be a good time to download the handouts. In addition, if you have any questions, please put them in the chat box. So at this time, please join me in welcoming James Rossi, President and Managing Attorney of Rossi Law Group, and a regular presenter for MacroPro and Friends events. James has over 20 years of experience in workers' compensation, along with a background handling catastrophic personal injury litigation and appellate work, including a case that reached the United States Supreme Court and created new law in the Ninth Circuit. Recognized as a Southern California super lawyer for the last 5 years, given an AV preeminent rating by his peers through Martindale-Hubbell, and named among the top 1% of America's most honored attorneys, it is my pleasure to welcome James Rossi. How are you today?
Good, good. Thank you. Very nice introduction. Better than most.
I see that.
It's always.
I see that.
It's James Rossi.
James Rossi, hello. And I see that we have the same background.
Yeah, I copied you because I'm in Pittsburgh and I'm not at my desk, so I figured I might as well try and look like I'm matching.
Yeah, everyone out there, we are not at the same place. We are not at the same place.
It sure looks like it.
But James, can you get me a drink first? No, just kidding.
Yeah, I'm going to be going and seeing the Dodgers play the Pirates in a couple hours, which will be pretty exciting. Yeah, it'll be really neat.
All right. Well, it looks like we have everybody there. We have a lot of attendees still logging in, but I think this is a great time for you to start.
Absolutely.
And we'll see you in a few.
That sounds wonderful. Thank you very much.
Okay.
All right. So let's get this slideshow working. There we go. All right. So what are we going to talk today about? We're going to be talking about just some of the challenging issues in workers' compensation. Some things that people have asked me and said, hey, what about this? What do you think of this? What do you think of that? So I've got a presentation for you all that's going to just discuss some of those issues. We're going to touch them, and I really hope it's helpful as always. It's one of the most important things I get out of these is to know that I'm helping the industry, and it feels good when I do. So particularly the regulars over at MacroPro. So it's wonderful to be back, and I'm going to go ahead and start. And the first thing we're going to talk about is the case of Vasquez versus Esencio Renteria, which is an in-bank case that came out last year. And the reason I'm covering it is because it threw a little wrinkle into something that we used to do quite often. This case puts an end to it, is when we would try and get an evaluation with the QME, if it wasn't in that 90 to 100 day period, we would be requesting a new panel so that we could potentially get a new doctor that would move the case. But sometimes, we don't like the doctor. We think that the doctor's inappropriate for various reasons, and this would be one of the ways that either the AA or the DA would find a way to get around it. So in this particular case, it was the defense who tried to get a new panel, and they did it because the PQME was saying that they could not get a date until 127 days past the request for the panel. Well, obviously, that is not a very egregious extension. 7 days is almost nothing. And obviously, also, if you were to get a new panel, you're probably delaying things another 4 to 6 months. Who knows? And in this particular case, it was even more egregious because this was a reevaluation. So they were essentially trying to change the doctor when in fact that doctor had already seen the applicant, likely reviewed records and all that kind of stuff. And so the defendant just wanted to see if they could get out of it. And typically they had all the law on their side. And then the WCAB in this en banc decision, they changed it. And they made it this kind of a weighing process. And I put the five elements that they're going to look at. In this particular case, they sent it back to the trial court so that they can assess these factors. Because obviously, if these factors didn't exist until this decision came out, then that's a triable issue still. So they're going to have to go back and look at it. But the reality is, with what I just told y'all, I can't imagine that they're going to end up with a new panel. And just think about all the litigation delays that were caused by all of this. It clearly is what I would consider to be some sort of a doctor shopping. And I'm not saying there was anything wrong with it. Both sides have done it. The law supported it, but now it doesn't. So they're going to look at the length of the delay. Here it was 7 days. As I said earlier, 4 to 6 months for a QME. The prejudice, well, how much is the prejudice? And every case is going to be different. You might have a case where the applicant is not getting their TTD because they need this QME to go forward, or maybe it's impacting PD or future medical findings, and the applicant's just going to have some prejudice if there's a delay, or maybe the defense is going to have the prejudice because they're trying to move the case and this doctor's keeping them from being able to do it. So they're going to look at prejudice. It's going to be common sense, in my opinion. They're also going to want to know what efforts were made. Did you make multiple attempts to get a new date? Did you ask to be on the cancellation list? How far did you go in trying to get that date? Did they offer a different office? Did they say they could do it via telemedicine? There's a lot of things that they can look at, and I don't know the answers in this particular case. But ultimately, the court sent it back down and said no more automatic panels changes just because it's beyond the 90 to 120 day period. So just know that you're up against a significant wall in the future on these. Both sides are, and frankly, with what I've seen in my career on this issue, it's a pretty dang good decision. So it's an en banc, which means all the appeals boards and judges in California have to follow it. The only way they wouldn't is if the appellate court came in and overturned it, or if they issued a new opinion and they undid this particular opinion, things like that. So for now, this is the law, and it's binding on us. All right, so next up, I hear a lot of requests to understand UR. Now, some of you are probably masters of it and have it all down, and others, it's pretty technical, and so I can understand it. So what we're going to talk about is a few of the what UR is in the process and IMR, and then we're going to go into the case, the Rodriguez case that came down, which essentially wiped out Patterson. So we're going to cover all that right now, and I'm going to point out a few tips that are important so that you could potentially avoid some pitfalls. So the first thing comes is a treating physician is going to issue a request for authorization to the defendant to have some treatment. The adjuster reviews it, and the adjuster is going to make a response to it. And they'll either approve it or they'll say, I'm submitting this to UR. If the claim's denied, then the adjuster is going to usually defer the RFA. I have seen it where they didn't, but that's the standard procedure and what is almost always done. Then if the RFA is sent to UR, you've got the UR physician that's going to review the request as well as all the documentation to determine whether it's medically necessary under the MTUS. And the MTUS is essentially a nationally recognized, peer-reviewed, evidence-based science, and that's how they determine medical necessity. So it's not like it's just some a doctor can say, I'm going to give A and B because I just think it was appropriate. They have to actually follow the MTUS. So then, so you got it. It comes in. UR. It's sent to UR. The UR physician's either going to approve it, or they're going to modify the request, or they're going to deny the request. Whatever that decision is, they're going to have to back it up with really good reasoning. The better it is, the easier it is to defend, and you hope it's real solid, substantial. And so once that is made, then it's got to be communicated. The decision's got to be communicated to the doctor or the applicant's attorney. And one of the pitfalls is if you don't make sure that all of these people are provided with notice, it can invalidate the UR. So you could end up with this wonderful UR, that very well reasoned, everything's perfect except for it wasn't communicated, and all of a sudden we could potentially have to go to trial on medical, which and lose our our IMR and UR procedures. So then we come up to the types of review and the time limits. So there's prospective review, which is the future. It hasn't happened yet. And so they're sending a request for authorization so they can get that treatment in the future. There's retrospective, and that's where the treatment has actually already occurred. And so they're now submitting it for UR after the fact. Then there's what's called concurrent review. And this is when it's someone is in an inpatient facility such as Casa Colina, and there's a request for treatment. Concurrent review will apply. It's only when there's an inpatient basis at a facility on an inpatient basis. So you're not going to see it very often, but in the emergency room or like I said, Casa Colina, where someone is staying there, they're inpatient, and so it's all three of these have different rules. And so what I've done for you under that is I've got a little bit of a diagram here that can help you understand the differences in terms of the time limits. So you'll see for prospective, you have to make a decision within 5 business days. The same goes for concurrent. However, retrospective, you have 30 days. And that's obviously because the treatment's already done. There's no urgent issues. The 5-day period that's to help the applicant. That's not to help the provider that already provided the treatment. So you got to know whether you're dealing with prospective, concurrent, or retrospective to know how long the period of time for the decision to be made is. The next is notice to the physician. So what this means, and this is something that is one of the pitfalls that you really got to pay attention to, is on prospective and concurrent, within 24 days of the decision being made, it has to be communicated to the doc, to the physician. And then there's another notice requirement for prospective, within 2 days written notice, and for concurrent it's 24 hours. So what I always say is within 24 hours, just issue written notice and you're going to be good for prospective and concurrent all the time. So, and you can kill 2 birds, 1 stone. I don't understand why some people would tell the doctor it's being approved to satisfy the 24 hours on prospective, but then they still have to do the written notice. Just do the written notice. Calling is fine as well, but make sure that written notice is done. And if it's done within 24 hours, you're giving the physician the notice. Then there's that statutory pitfall, jurisdictional shift down there. If any deadline's missed, the WCAB is essentially going to gain jurisdiction. Not in every single case. There's some arguments that I think you could make. So, for example, if it's a service issue and it say it wasn't served on the applicant, but it was served on the applicant's counsel, or vice versa, I would argue that potentially you could be excused for that. But you're going to be litigating it. You're going to be dealing with a mess that you don't want to deal with. So I just say get all your deadlines correct. It's critical. And if you do so, you're going to save yourself some pain and worry. All right, so this is another one. This is a big one. Expedited requests. This is the one that has given me a lot of nightmares over the years, and it's a situation where the applicant faces an imminent and serious threat to their health, or just common sense. There's a reason that it's expedited, and you should. When I read them, I usually know, and I feel you guys would all probably be the same, if it makes sense or not. But you're not the one that gets to decide whether it should be expedited. Now, the reason why expedited is so important, because those timelines that I gave you get reduced, and it's not even business days. It's 72 hours. So they could give you a 3 p.m. on Friday. You have 72 hours to make the decision, even though there's a whole weekend in between. And so that box that I've put in there, you'll see there's a red check. That's the RFA. the left upper corner of it, when that box is checked, that's when you got to get into expedited mode, and you should always be looking straight for that, because it's something that really shortens the time for which we can respond. Now, when it comes to the improper handling of expedited RFAs, it's I mean, in my opinion, it is definitely the most common cause of an untimely UR. So you want to make sure, anytime I've had issues with timeliness of UR, it's always this expedited review request. It gets the carriers, et cetera, because it's tricky, and they use it in certain instances to be tricky. So the expedited, they'll do it, and as I said earlier, they may do it on a Friday at 3 p.m. And so you're going to want to make sure that it gets handled, and you're going to want to make sure you've dotted your I's, crossed your T's. And sometimes what happens is the expedited is clearly not warranted, or at least maybe not to you or I, but the doctor says it's clearly not warranted. And so they have to review that within 72 hours. And so let's say they decide that it wasn't warranted. They have to issue their opinion that it wasn't warranted within the 72 hours. So it really is still a trick. It's still a pitfall, because even if it wasn't proper, we still had to respond that it wasn't proper within 72 hours. So these expedited requests, they upset me at times. I've seen them a number of times where literally they come on late on Friday. It's something that we've denied a bunch of times over the years, and they just keep doing it, and they always do it as expedited, and they're trying to get us. And it's just clear to me that that's what's going on. Not always, obviously, but some certain providers, as soon as I see it, I think go check it, because they're notorious for it, in my experience. So make every determination within the 72 hours. The key takeaways: calendar all your UR deadlines immediately upon RFA receipt. Treat expediteds as a 72-hour hard stop, weekends included. And that means even if it's just to say it shouldn't be expedited. But I always feel like I don't understand why you would say, hey, it's not expedited, so we have 2 more days. Why don't you just decide it right then and there? If you could decide it wasn't expedited, you can just decide it. So that's something that it perplexes me if they do that. The next thing is, if you're disputing expedited status, ensure that timely physician determination. Verify service info before issuing your UR decision. Again, you could leave off a party and the whole thing's messed up just by leaving off the AA or the applicant. Now, again, I said there are arguments, but you don't have to make them. You don't have to go to litigation over these types of things. And you certainly don't want to miss deadlines giving the WCAB jurisdiction. All right, so you got UR, and it's a timely UR, everyth's good. The adjuster approved. Let's say the adjuster approves it in the first place. You're not going to challenge it. If the defendant, if their UR physician approves it, you're not going to challenge it. The adjuster actually does stand in the shoes of a UR on that first step, which is I approve. Once they don't want to approve, it's out of their hands. So if typically the UR physician is going to either accept, deny, or modify, and if they deny or modify, that can be appealed to IMR. Those are the key situations where IMR is appealed to. Generally, the applicants have they have 30 days from the UR decision to apply for IMR. And any aggrieved party can appeal an IMR decision. However, I've personally, actually, I take it back. I have seen it once, and it was because not all the records were provided to, actually, I've seen it a couple times where the records were not provided to the UR physician, and there were missing documents. Another thing it could be is maybe the facts submitted to the UR physician were incorrect, things like that. that's pretty much the only one I think that has teeth, because there's another one. It's like the reviewer made the decision, it was biased based on race, etc. I don't know how you would ever know that, because you don't know who it is that's actually doing the review, because they don't put the name of the doctor. So the appeals are very, very limited. They're very difficult. You probably hardly ever see them, other than maybe the situation that I just mentioned. All right, so then Patterson. Now this, gosh, this case, this was a nightmare case for so many years. I have had to litigate this issue so many times, and it's just always been so difficult, because you've got an applicant in inpatient care at Casa Colina, or you've got an applicant getting home care, or you've got an applicant who is being treated by a nurse case manager, and it's been approved, and they say, well, you have to keep approving it until there's a change of circumstances in the applicant's condition. And we get it all the time. Litigated this many times, and it's always hard for the defense because of this case. And it's ridiculous. AAs would file expedited hearings. They would and force us there so that they can get around it. It was just, to me, it's ridiculous. And so ultimately, last year, we got a California appellate court case that came out called Rodriguez, which essentially said this shifting, burden shifting framework that was established in the Patterson case is not proper. They found that Patterson is essentially, at the end of the day, is no longer good law, and they say that it has to be UR and IMR that controls it, which was the whole point of it all, because we went to, they wanted to have UR and IMR determine medical treatment needs rather than QMEs, et cetera. And so this is their whole point. So they don't want to see the WCAB having jurisdiction over these medical issues, these judges who are not trained in medical making the decisions. Now, certain situations they obviously can, like if we mess up the UR and IMR process, but if we do it correctly under the Rodriguez case, we would be good. Now, the problem is that in January, it was accepted for review by the Supreme Court. And so what that means essentially is, as great as this case is, it's not binding law yet, because it has to, because cert was accepted by the Supreme Court. Now, I will also say Patterson's not good law, because right now you've got a California appellate court case that is trumps the Patterson case, and therefore Patterson is no longer right now. Now, what'll happen on these issues, I can't say with certainty. I can't say with certainty the Supreme Court won't disagree with the Rodriguez appellate court, but at the same time, this is an outstanding case for us, and I've already actually used it to resolve a number of these types of issues on real high exposure claims that I've been litigating these types of issues, and they're now gone, and I heavily use this case. And so I'm bringing it up because, you got to make sure you follow the UR process to the T, nail it, and if you do, and you do it all right, then you can avoid this situation where you're getting in front of a judge, and that judge is awarding future medical treatment, or not future, but just medical treatment based on their opinions as opposed to medical opinions. So great case. Do your UR, your IMR, all your deadlines, do it all well, and then we'll see where this case goes. But hopefully it's going to hold, because it's really, in my opinion, it's a very important. Someone's raising their hand. I'm not really sure what that means, but in my opinion, this is one of the most important cases in years. But if you don't do UR and IMR right, doesn't matter. You're hurting yourself. All right, here's the next case I want to talk about. It's called Nunez versus California. And this case discusses vocational apportionment. So what used to happen is we'd go to the AAs typically would get a vocational expert, and the vocational expert would say, yeah, I think this person's 100%, and here's why. And they would completely ignore whatever the apportionment was by the medical doctors, and they would substitute their own in. And so it would make defending against these bad vocational reports difficult. And so this Nunez case came out in bank, so it's got to be followed by all work comp judges and appeals boards throughout California, unless there's a law change, which there's been no change. And so these vocational experts have to follow the medical apportionment. They can't substitute their own. So, for example, if you've got a 100% case, and based on the vocational expert, he says you can't work, blah, blah, blah. But you have a medical opinion from the QME saying that it's 60% apportionment to industrial and 40% non-industrial. Well, you effectively, in my arguments in most cases would be, have you turned it into a 60% case? And so this is a critical case that came down. It's a wonderful case. And if you've got real strong QME reporting, you could potentially not even have to get a VR expert to challenge the applicants. I mean, if it's a really good one, then they come up with some great reasoning, and it's a high exposure case, I would get my own. And I've got a few vocational experts that I use that I trust, and so I'll go to them. But otherwise, if I feel like the PQME is real solid, then I probably won't even recommend going to get our own report. And so the way I've used this case as an example is I go to the doctors and I say, hey, doc, can you apportion this? Can you apportion that? And I try and nail them down so that I get solid medical apportionment, and then I can defeat these vocational expert reports. So it's an outstanding case, outstanding for all of us on the defense side. All right, so obviously this is going to be one of the craziest and most difficult areas that we're going to have to navigate as an industry coming up is AI. I'm just going to touch on it. I just want to give you all a few pitfalls. My experience is that a lot of people are not very familiar with how AI works and all the different platforms. And it's extremely, extremely important that you understand it if you're going to use any AI. But first, before you even use AI, you need to make sure that your employer is okay with it, because your employer is going to probably be launching policies and procedures on what is safe and proper use of AI for you, and you're going to need to follow that. But regardless, I just want you to understand some of the things going on so that you realize why it's so important to be very, very careful. So the California Bar recently came out with an advisory for attorneys in terms of our duties, and they essentially narrowed it down into the three biggies. There's a few other things too, but one of them is competence. And that means that we have to, as an attorney, we have to understand thoroughly the AI that we use and how we use it, and what the ramifications are of that use. And I see it already a lot in the industry where it's being used in ways that the user has no clue how it really works. And I'm going to explain a little bit of it to you guys. The next one is confidentiality. That when we put, strategy, client facts, medical information, things like that into the AI, we could be violating the duty of confidentiality. And then the last big one is, I'm sure you've heard stories about it, is candor and verification. And that's, for example, citing fake law. Well, if it's fake law, then you're breaching the duty of candor, because we are not supposed to be putting fake anything into our briefs, etc. And so we have to understand how the AI works, how all of this works, so that we don't make these mistakes. So that's attorneys. Adjusters have the same types of rules. And in fact, insurance companies, I'm not an expert on this by any means. No, I don't claim to be, but it's my understanding that insurance companies have even more strict rules than attorneys when it comes to this stuff. So you need to be very careful. The first one is claim handling and penalties. You don't get to say, well, AI told me this, and that's what I based my wrong indemnity payments on. You don't get to say that. The other one is accuracy and verification. It can fabricate information, and there's no it was AI excuse. You don't get it. Privilege and work product. This is a big one. Let's say, for example, I send you a detailed analysis of a case, and you put it into the AI, and it's ChatGPT or Claude or Gemini, one of these AI platforms that are not enterprise. Enterprise is, I'm not going to get into the technicalities on all this, but enterprise is really the only safe way to use AI, and that's because it doesn't train based on your information. Now, all these others train based on your information. So when they have a privilege, when you have privileged work product put into it, it then remembers all that so that it can train itself for the future when other users have questions, and that's how they do it. And you just might be waiving the privileges. And the same goes on the next one, confidentiality and data security. You can be waiving privileges. You can be violating HIPAA or SEMA, whatever the rules are that apply. We, as work comp technicians, adjusters, attorneys, we handle very sensitive information. And the last thing we want to do is put that information into some public AI platform like ChatGPT and risk, violating some serious laws. The next one is good faith and non-delegation. You obviously have to do everything in good faith. And so you can't say, oh, well, the AI gave me this wonderful analysis, and I just didn't realize it had a few errors in it. And so there's my defense. It was AI created. That's never going to be a defense, and nor should it be. And the last thing I want to tell you on this is there's a discoverable digital footprint. And what I mean by that is when you type in to ChatGPT your inquiries and you get into this deep discussion, which is amazing, don't get me wrong, I absolutely find it just amazing. I can't tell you how many things I've figured out that are not legal related using ChatGPT, including very technical things. It's amazing. You can take pictures and things like that, but you can't do any of that with the law. You can't. We're dealing with such sensitive information, and so let's say, for example, a brief is filed, or you prepare something, or the attorney prepares something, and it looks like it could be AI. Or it looks there's some indication that a privilege was violated. There's actually cases where the digital footprint is the courts are allowing the digital footprint to be discovered by the other side, and they can see everything you typed. So if you were trying to develop a defense, which is not unreasonable, we develop defenses, but if you were trying to develop a defense and it looked like you were doing anything you could to make an argument against the applicant, that could be potentially used. And so you could waive our attorney client and work product privileges. It could be devastating. So it's so important that you understand all these rules much more than I'm even talking, because I'm literally just touching the surface of this. It goes so much deeper, and it's fascinating, but at the same time, it's dangerous. So just be real careful. I will tell you a story about a colleague. I've got a colleague who prepared a petition for reconsideration, and he did the recon petition, had it finished, and then he decided he wanted to run it through some AI. And he runs it through the AI, and he sees, I like the way it changed the headings, and I like how it reframed this argument. And what he didn't notice were there were 3 citations that were just added after the law, and they were not correct. I think one of them was completely fake, and 2 of them, I think, didn't stand for the proposition that they said they stood for. I can't remember exactly what it was. And so this thing gets up to the recon unit, and they want to issue sanctions because they say you cited fake law, and which is a major problem. They ended up granting the recon because there was law supporting his position, but it still had this ridiculous errant citations that were fake that should have never been in. And it happened because the attorney didn't realize that AI could do this. This was a while ago, by the way. This was probably a while ago. Sounds like a while ago. Probably like September, I want to say, of last year. So I mean, AI is just so new that that is a while ago. But so he essentially he's an outstanding attorney, one of the best, and he made that mistake, and he's paying the price for it because it's brought him a lot of grief, and it's upset him a lot, and it's not something that he would normally be involved with, but he is. And there's a lot of cases that are really bad out there where there's 20 something citations, they don't even check them. They know they didn't create them because the AI did the whole thing, and they still send it out with wrong information. And there's countless stories across the United States like this. So it's very dangerous. We're not there yet. We're just simply not. We're close, but we're probably a good year away from really relying on things. Never are we going to be able to fully rely on it, but it's going to be something that will be less likely to make those errors, and then we still got to catch them. All right, next up, the presumption of compensability. This one, I was at a presentation, I don't know, in the last 3 or 4 months, and this was a hot topic, lots of questions from adjusters. And so I wanted to go over the presumption of compensability and the 90-day rule with y'all, and I'm going to give you a few pointers as well. So essentially, that claim form you see there on the left, that's the DWC-1. That document is what controls the start of the 90-day period. Essentially, once there's an injury, the applicant reports it, and within 1 day, they're supposed to have the DWC-1 provided to them. And then once the applicant turns it back into the employer, then the employers have 90 days from receipt of the claim form to investigate, evaluate, and accept or deny the claim. And it's a rule, and I know many of you are, you really worry about it because we just have I worry about it. We have such a short timeline to investigate claims, and it's not like we have to do all of our discovery, but we have to act in good faith such that we take the steps necessary to evaluate whether denial is appropriate. And if we have enough evidence to issue the denial, then we're safe, and then we can continue to develop that evidence further. But if the denial is late, then it's almost the same as no denial at all. I mean, there's certain exceptions, like I had one where I got around it by impeaching the applicant so bad that I showed he had no credibility, and essentially it was fraud. Well, that's an exception. It's not intended to allow fraud, but it does take away some really good defenses. You could lose a post-term defense, which is absolutely my favorite. Any of those types of defenses, you can lose them. Intoxication, which can be a gigantic one. My experiences with intoxication, and maybe it's just the subset of claims I have, and maybe I'm not right on this, but it seems like intoxication has resulted in my experience in a lot of bigger injuries. And maybe it's because they're falling from heights or car accidents, things like that, where there's just a lot more likelihood of severe injury. But someone who's intoxicated is more likely to make those types of mistakes. But it's not a defense I would want to lose. That I can tell you. Then there's some defenses that you don't lose, like the psych defense, good faith personnel decisions, the 90-day or the 6-month rule of employment, employment itself. You can't apply the presumption to a non-employee. There are exceptions, so just know that. But there's a lot of them, they're not going to be accepted. So then we had the case of Honeywell, and this is the case, Supreme Court of California. This is the case that found the DWC-1 is what controls the 90-day period. However, they also talk about the exceptions to that. And so essentially, if there's bad conduct, to sum it up, if there's bad conduct that was relied on by the applicant, and that's the reason they didn't provide the DWC-1, then there's a potential that the presumption is going to apply. So even though the DWC-1 was much, well in advance and timely in terms of when it was turned in, and it was within 90 days, maybe it was even day one, that could still be a problem if in reality, the fact that it took that long from the date of injury was because the employer misrepresented or misled the applicant. So you're always going to have to look at that when you get a late DWC-1 and you want to start your period on that day. What happened before it? Why was it turned in late? And is there an argument that they can say that the employer is stopped from making the argument? All right, so now what we're going to do is I'm going to give you a few examples, and these are actually from real cases. So these are not something that I just made up or I just wanted to run it. And these are my opinions. These were actual cases. So let's see if you guys can get these right. The first one is a case called Ellman versus Capstone Logistics. In that one, the applicant was injured on 7/28/2015, and he reported it to his supervisor the same day. So 7/28/15, employer knows. Then the claim was denied on November 13th, 2015. So the denial was 108 days after the date of injury and the first report to the supervisor, 95 days after applicant's first request for treatment and lost time. So over 90 days for that too. The DWC-1 was submitted 77 days before the denial and 71 days after the application for adjudication was filed. So the answer is going to depend on what starts the 90-day period. And in this particular instance, there was an argument that, well, it was reported to the supervisor. Not only that, we filed an application. I mean, they knew what was going on. There was a request for treatment. And so ultimately, you would think, okay, well, even if it's timely, there may be an estoppel argument. And so they didn't find that there was enough evidence due to the level of the supervisor. He wasn't high enough level. And they ended up saying they did not find estoppel, and they said it was timely. And it was because the denial was 77 days after the DWC-1 was submitted to the employer. So here you got date of injury and first report of injury, request for treatment, and lost time, all before the 90 days. It extends beyond the 90 days, and yet it was still timely. And that's because the DWC-1 controls, as I mentioned in the Honeywell case, which was a California Supreme Court case. And this is frankly one of the most misunderstood rules that I come across, not just adjusters, attorneys, you name it. I can't tell you how many times over the years I've interviewed an attorney and said, explain to me the deadline for the 90-day rule, and how often they get it wrong. It's just amazing to me. So I always stress it, just as I'm doing here today, so that you get it right. Next example, and this is based on a case called Solis versus Carter Inc. The applicant was injured on 8/31/2012. The defendant denied the claim on Friday, 1/4/2013, which is obviously more than 90 days. The denial was 126 days after the date of injury, 114 days after first treatment, 101 days after the application for adjudication. So even an application for adjudication was filed 101 days beforehand. The denial was 78 days after the DWC-1 was provided to the applicant. Now, that last fact is important because that's saying that the DWC-1 was provided to the applicant, not that the applicant turned it back in. So, because remember what the Supreme Court case said, that there's got to be a DWC-1 turned into the applicant. Now, aside from the estoppel arguments, et cetera, in this case, they didn't find estoppel. They found it was timely because there was never a DWC-1 turned into the employer. That starts the 90-day period. All right, the last example is based on the case called Frosto versus WCAB, and the applicant was injured on June 29, 1992. Defendant denied the claim on Monday, 10/19/92. The denial was 112 days after the date of injury and 91 after the claim form was submitted to the employer. So we're 1 day over. Was it timely? It was again. And that's because the 90th day fell on a Sunday, which gave an extra 1 day because it couldn't end on a Sunday. It was a weekend. So in that case, they were timely as well. So you can see that the whole point of these three cases, I'm definitely not telling you, you'll always be okay. But the fact is, it's typically when that DWC-1 is provided, and hopefully there's no estoppel argument or anything like that. But that's not how I personally calculate it, and I'll get into that. So some general tips. You need to promptly investigate claims using your reasonable diligence. And that means as information continues to come in, you need to evaluate it and reassess your positions. So let's say, for example, you've got a denial. You deny the case, and then you get some evidence that suggests it shouldn't have been denied. You have a duty to review that evidence promptly using due diligence, and if appropriate, reverse your decision. And you have to do this nonstop. That's your duty as an adjuster, is you always have to promptly investigate and use due diligence in evaluating everything. And that includes whether to accept or reject a claim. The next one is, in this is a tip that I give because I just don't like the thought of dealing with a presumption when it comes to the presumption of compensability. And I have seen a few violations in the last 6 months where there were denials that were not timely and having to deal with that. Of course, it has to be raised by the other side. I had a case once where we paid out a ton of benefits, ended up they sent the file to me, and after some investigation, we realized this guy was a liar, and we went to trial, and I didn't even have to use or defeat the presumption of compensability. The AA never even raised it. I couldn't believe it, and so it's definitely something to think about. So what I do, though, is I always use the date of the injury to start the investigation period wherever I can. And the reason I say that is I can't tell you how often I've seen it where the DWC-1 is turned in, 20 days later, or most often it's turned in through the applicant's attorney, and that's how we find out about the claim. And the problem with that is if you have an applicant who says in the deposition, oh yeah, I turned in the DWC-1 on the date of injury. And now if you did it based on the date of injury, you got a late denial, whereas if you did it based on the day you received the DWC-1, you still have a timely one. Now, I think you'd still prevail if it's real and true that the employer really didn't receive it until later, or until the applicant attorney. But all it takes is an applicant to say, I did it, and now we're litigating it. And now I got to litigate the presumption. So I don't want to litigate it. And if I go based on the date of injury, I'm never going to have to litigate it. Now, you don't always have that option. And sometimes sometimes you arguably have already missed your 90 days. You don't learn of the claim until 90 days later. So you're going to have to operate based on the receipt of that DWC-1. But if you get the claim early on, 2 weeks, 3 weeks, whatever it is, and you're just not sure if there's a DWC-1 filed, take care of it and just use the date of injury as your date. If you have the evidence you need to deny it, you have the evidence. Another tip I'm going to give you, this is a big tip because I've seen big problems from this for adjusters, is when they use the post-term defense. Post-term defense is probably my favorite defense. It's a good defense. And so what happens though is an overzealous adjuster sees that the applicant resigned and is no longer with the company, and they issue a denial based on the post-term defense. And the reality is that this person was just a single resignation, not part of a group, and never was terminated. And so by raising that defense, the applicant attorney gets it in their possession and says, oh, you were terminated. Well, guess what? I'm filing a 132A petition for penalties for discrimination for filing a work comp injury. And so now all of a sudden the employer's got this petition for penalties that's not insurable, that they typically have to defend themselves. And it was all caused because an adjuster claimed post-term when there was no post-term. So what I always advise is when you're using the post-term defense, get an email or writing or something from the employer saying they were terminated. Get the documentation. Don't just apply it because the applicant says they resigned or you think that there's termination. Document your file, protect yourself. And then the last point I'm going to make is to document your file well to reduce audit and litigation exposure. There's a supervisor in Fresno who's always said, and it sticks with me, and I've said it many times, and I always give him credit because it's his, but if it's not in the file, it doesn't exist. And so if you're relying on something to deny benefits of some sort, et cetera, or your rates and all that, you need to make sure your file is documented so that it survives an audit. And that's it. We are officially done.
Hi, James. Are you able to upload the presentation because it's not in the paperclip?
Yes. Oh, you mean?
Okay, before. Yeah. The handouts that.
I definitely can get them.
Sees them.
Nobody sees. Okay. I don't know how to do that here. I'm not usually the one that does that.
Yeah, I know. They were uploaded. I'm not sure what happened, but okay, we'll get, we will, I noticed everyone that they could email me and I can get those handouts to everyone at Graciella, GRACIELLA at macropro.com. I did put that in the chat box.
I don't know if you can see it. I'm trying to show you my reference sheets. You guys have seen them. Anybody who wants the defense's reference sheet, please put that in the comments and we'll mail it to you, laminated copy. And remember, it's wonderful for listing all your defenses when you issue your denial. So you got all your code sections and the various defenses available. But if you need a copy of that, or you've had one in the past and you need a new one, just put that in the comments and I'll make sure you get a laminated copy in the mail.
Okay. All right. Before we end, James, I just want to let everybody know that we have a fantastic lineup of additional webinars this week. You can sign up at www.macropro.com. Tomorrow we have Dr. Ammon, who will be talking about how to optimize functional disc recovery. And on Wednesday, we have Jeff Zillett, who will be talking about examining clinical pathways for occupational injuries. I don't know. Yeah, in the question box, all we had was everyone would. You did such a great job that people want your handouts, which is great.
Yeah. I definitely want to make that available. If you can they make the request to you in the chat? Okay, if they do that, I can email them too.
You can email them. Okay, that'll
Yeah,
be great.
that'd be good.
But yeah, well, thank you so much, James. You always do a great job at our webinars, at our Macro Pro in-person events, and thank you so much for taking the time to join us
My
today.
pleasure. My pleasure. Thank you,
Well,
everybody.
all right. Have a great time tonight.
Thanks. Go Dodgers.
Thanks. Bye.
Bye.
Goodbye, everybody. Thanks. Bye.